Our next speaker this morning is Mr. John M. Fuke, who is seated on my right. John was called to the Bar of Ontario in March 1965. He's a graduate of the University of Toronto Faculty of Law, and near and dear to both our hearts, I should say that he was editor of the Faculty of Law Review when at law school. He is a member of the firm of Fraser and Beattie, chairman of the Wills and Trusts, or past chairman of the Wills and Trusts section of the Ontario branch of the Canadian Bar Association. John was for some 5 years a group instructor and a lecturer in the Estate Planning and Administration section of the Bar Admission course, and is presently secretary of the National Wills and Trusts section of the Canadian Bar Association. Ladies and gentlemen, Mr. John Fuke.
The topic that's been given to me for this morning is income tax planning. And before I get into it, I want to give credit to two of my associates, Pat Williams and Bonnie Kroll, for the help which they gave me in preparing this. In fact, they gave me so much help that I came here this morning to hear what I have to say. But I'm reminded of the story of the politician who had a very good ghostwriter. But he never gave the ghostwriter any credit. And he used to make inordinate demands upon the ghostwriter and say, give me a speech. I'm lecturing to such and such a group, and I want a speech, on these topics, and the ghostwriter would dutifully go away and prepare the speech. This one particular time, the politician, who was becoming quite famous because of the quality of his speeches, rushed to the ghostwriter and said, look, I've got a chance to speak to the United Nations. This has got to be the best speech of my career. So I want you to do a really super job. He says, all right. He said, when do you want it? I said, I want it by tomorrow afternoon. So the ghostwriter shrugs his shoulders and mutters and goes away. Well, the politician, being a very busy man, grabbed the speech the following afternoon, didn't have a chance to read it, rushed to the United Nations, got up on the podium and was delivering the lecture, and my God, was it ever super. The analysis of the world's problems was just fantastic, dead on. Everybody was listening. You could have heard a pin drop. And he was going on, and he came up to the high point of his speech, and ladies and gentlemen, he said, the answers to the world's problems are as follows. And he turned over the page, and it read, from now on, you son of a bitch, you're on your own. For the purpose of today's lecture, I'm saying that income tax planning means the maximization of the after-tax income earned in a family unit. And this is going to be this may be accomplished by taking full advantage of the available deductions and opportunities to defer income, by spreading income among the members of the family unit so that all of the available personal exemptions, deductions, and low marginal rates are used, and, where appropriate, using a holding company. So far as available deductions are concerned, I've divided them into two types. One, deductions in respect of certain types of savings which are encouraged under the Income Tax Act, and secondly, deductions of certain annual items. With respect to types of savings, Wolfe Goodman has already talked to you about deductions to registered pension plans, deferred profit sharing plans, RRSPs. These, of course, there's a deduction for the contribution as it goes in, and ordinary tax when the payments come out of the plans, and there's no tax on the earnings in the plan until their withdrawal. The next category is a contribution to a registered home ownership savings plan. These are, of course, of not much interest to most of us because we already have houses, but for a young person who is 18 years of age or over, he may have his own RHOSP, and he's allowed a $1,000 per annum deduction to a maximum of $10,000. This is deductible against income from all sources, unlike the contributions to a pension plan, DPSP, RRSP, which is deductible only against earned income. An individual may claim the $1,000 deduction to an RHOSP against contributions to against income from investment sources. this comes up, this is important in, as I say, family income tax planning. The other point, too, is that the $1,000 is deductible when you come to compute the net income of a child for purposes of determining whether he has lost his dependent status on his father's tax return. Then there's no tax on the $10,000 that's put into the plan and the income earned on it if the money is used to buy a house. And again, as we all know, it's important to make your contribution for the year to your RHOS before you enter into your agreement to buy your house. Third category of investments, of savings, money is set aside as savings that are deductible in computing your income tax, are the investments in tax shelters. I'm not going to talk in any detail about tax shelters. Those topics have been, the various types of shelters have been discussed at great length. In particular, there are papers in the 1978 conference reports for the Canadian Tax Conference, and the 1978 papers arrived on my desk this morning. What are we left with, though, in the way of shelters? MERBs, the time for MERBs is over. The buildings had to have started by the end of December of 1979. It's still possible to buy somebody else's interest in a MERB and still get the advantage of the MERB, which was that you could claim the loss occasioned in the building by virtue of claiming capital cost allowance. That loss you could set off against other income. There are, however, going to be no more soft cost deductible because they were only deductible in the year in which they were incurred. The second category of shelter, which is still in existence and not harmed in any way by budget changes, was certified feature films. Again, if this is a Canadian feature film, etc., the individual investor is allowed to deduct 100% of his investment in the film in any year. The normal form of investment is some cash plus a promissory note. Now, originally, when these film investments came forward, the practice was to have the note, to provide that the note was only payable out of income earned on the film, a so-called non-recourse note. Revenue Canada then stepped on that and said that unless the taxpayer was at risk, he could not consider the promissory note to be an investment. So as a result, this non-recourse feature is no longer a part of these promissory notes, so that technically then the individual is at full risk for both the cash and the promissory note. Now, the other point, too, is that if the film makes any money, and by the way, hands up all those who've invested in films who've made money. In other words, really what a film now seems to be is a super tax loss. Anyway, should you recover anything on the film investment, it's 100% income. Because because you've got a full deduction in the year of investment, there's no cost, if you like, for tax purposes, so everything is income as it comes back. Third category is oil and gas syndicates. I've lost track, frankly, as to where we stand now with respect to the changes. And the boy, no, I won't ask you. But the rules with respect to 1979, and they were going to be changed by the budget, were that for exploration drilling syndicates, you could deduct 100% in the year the money you spend in exploration drilling. You could deduct 30% on a reducing balance basis of the amount you invested in development drilling or in buying producing wells. Now, I believe those percentages were going to be changed, were they, by the budget, or were they going to be stay put? Nod. Okay. The one feature, though, that was definitely not continued, that died, was the frontier exploration drilling, and that was the Beaufort Sea or the Canshore funds, which allowed you a 166 2/3% write-off of the of your investment in the fund. So the ability to put together those funds is going to expire, I think, at the end of this month, and there are no more funds in the works, so far as I know, that will be able to take advantage of this. So basically, the number of tax shelters that is available is shrinking dramatically. The fourth category of a deduction, as I've categorized it of money set aside for savings, is money that's used to purchase an an income averaging annuity contract. Basically, well, as you all know, if an individual realizes a taxable capital gain in a year, he can get a deduction for the amount of money he puts into an IAC, which is roughly all but what would be 1 year's payments under the IAC he can get the deduction for. And therefore, the effect is that he spreads the tax on the capital gain out over the term of the annuity contract. All payments coming back on the contract are subject to income. Are included in income and subject to tax as ordinary income. So therefore, it was thought, well, why would you want to buy one of these IACs if you were already in a top marginal bracket, and you always will be throughout the whole term? You could see it if you were in a 62% bracket, but in a few years' time you'd drop down to a 50% bracket or lower. Then you could see the advantage of deferring the income. The advantage, even when you're in a 62% bracket, is the fact that if you don't buy the IAC, the entire money that's going to pay tax is going to leave your pocket right away. If you do buy the IAC, then you're going to at least defer paying that tax for a while, and you'll be able to earn some income on the money that's eventually going to go to the tax collector. Now, moving to deductions of an annual nature, we've got our personal exemptions, which are for 1979 were $2,670, and if you're over 65, you get another $1,660. These are now getting quite significant when you put them in the light of every member of the family is eligible for these personal exemptions. We've also got the dependent deductions, and again, you remember I mentioned that, well, all right, number one, if a child earns over a certain amount of money, he loses his eligibility. His father no longer is able to claim him as a dependent, but there are certain deductions against the child's income from other sources in arriving at the net income of the child. One of them is contributions to a ROSP. The other very important one are school fees, so that a child who is attending a private school and perhaps running up fees of maybe $3,500 a year, though if he has income of that amount, he can deduct his school fees against that income in determining whether or not he is still a dependent. Then there's the interest, dividends, and capital gains deduction of $1,000. The only point to watch here is that the source of the dividend must be from an arm's length source. It can't be, say, from a family investment corporation. Capital losses get a deduction of $2,000 a year against ordinary income for capital losses. One thing that is being discussed now that the bond market has gone to hell is the fact that you could, if you still like bonds, to sell your existing portfolio of bonds and buy a similar but not identical portfolio of bonds, thereby realizing the loss, the accrued loss, but yet you still have your portfolio. Then you're able to carry the loss back against 1979 income and then get the $2,000 a year loss on into the future. Now, mind you, of course, if the bonds go up in value, you're going to get a capital gain when you eventually dispose of them. The point here, though, is that you can't just sell Government of Canada bonds of a certain series and buy the same series back again, because that's identical property, and you'd have to stay out of the market for 60 days in order to avoid that being categorized as what's called a superficial loss, and therefore you would be losing your deduction. But if you, for example, switch from Province of Ontario to hydro, that would not be identical properties. Investment counsel fees and custodians' fees are also deductible as expenses incurred in earning income. Another deduction is the cost of having a tax return prepared. The Revenue Canada takes the view that if it's normal that you have your books prepared by an accountant, and it's also the usual practice to have them do tax returns, well, then the fees paid to the accountant for the tax return are also deductible. And I think it's also, in the nature of business, I think that any professional would be able to deduct the cost of having his income tax return prepared. With respect to medical deductions, I spent some time yesterday tracking this one down. One spouse may deduct the medical expenses of both of them. For a taxpayer who is already earning significant income, he can't deduct his medical expenses unless they exceed 3% of his income. On the other hand, if, say, the husband is the main breadwinner in the family, but the wife has got some income, her 3% of income is a much smaller figure, so she can take advantage of the deduction of the medical expenses. So Revenue Canada doesn't care who paid them, but they will allow either spouse to claim the deduction. With respect to premiums paid for private insurance plans, that again is deductible as a medical expense, but you can't deduct as a medical expense something for which you are going to be reimbursed, either by a private scheme or by OHIP. The other point, too, is that the child's medical expenses may only be claimed by the parent who is also claiming the child as a dependent. But I'm not going to be liked very much by our office manager as I ask him to break out how much of what we pay to Confederation Life is allocable to the group health plan as opposed to the group life plan, etc., and how much is allocable to my wife, and how much is allocable to me, and how much is allocable to my daughter. Next deduction is interest expense. Wolfe Goodman talked briefly about the so-called interest-deductible mortgage. But the basic principle is you're only allowed to deduct interest on money borrowed to earn income. Money borrowed for personal expenses, the interest on that is not deductible. So therefore, just basically to use capital to pay off non-business debts, such as the house mortgage, and borrow to make investments. A classic case I heard of how not to do it was an individual who was so impressed, this is several years ago, with how high the Canadian GIC rates were, but how low American mortgage rates were. And he then went to Royal Trust and invested $100,000 in a GIC up here, then went down to Florida and bought a condominium down there or a house in Florida and borrowed the money from Royal Trust down there, pledging the GIC up in Canada as being a collateral. The problem there was he had taxable income from the GIC and non-deductible interest expense on the mortgage on the property down in Florida. He should have reversed it. Bought the place in Florida with his capital. Then after he'd bought it, borrowed money on a mortgage to invest in the GIC if it was a worthwhile spread. Now, again, another point is this, that the deductibility of interest is not limited to the income earned on the investment in any year. So that if you're investing in a portfolio of common shares, is highly likely that the interest expense will exceed the dividends earned. You can still deduct your interest expense so long as the interest expense is reasonable relative to the investment. There were some investments in deferred annuities which Revenue Canada objected to because they felt that the interest expense was never justifiable in the light only of the investment. They felt it was only justifiable in the sense of getting a shelter. Interest is deductible on money used to borrow an income averaging, interest is deductible on money borrowed for the purpose of buying an income averaging annuity contract. And again, that's a good deal if you think you can earn more money if you can earn more money with your freed up capital, then you're going to pay an interest to the bank. One situation, say, is the individual who has got capital now because of a sale which gave rise to a capital gain, and he's considering buying a house. What the individual there should do is to take the capital, buy the house, borrow the money to buy the income averaging annuity, and perhaps finance the borrowing with a mortgage on his house in order to fix his interest rate rather than be at the peril of having interest rates go up. Again, you can deduct interest on money borrowed to make payments to a registered retirement savings plan, but not payments to your spouse's RRSP. Now, another category in this same area is that of the deferred recognition of income. Number of investments whereby we can earn income but not pay any tax on that income until sometime in the future. The simplest illustration is investment in Canada savings bonds, which have the compound interest feature. There you won't pay any tax on the income until the bond matures. Another category is the type of share which is paying a stock dividend. For example, International Nickel or Inco pays a stock dividend. You don't pay any tax at the time you receive the stock dividend, but ultimately on the sale of the dividend, it's the entire proceeds is a capital gain. So you can postpone your income and you change the quality or the character of the income on its ultimate disposition. The third category is a deferred annuity, which I mentioned earlier. But basically, with a deferred annuity, you're paying premiums now for an annuity that's going to start sometime in the future. The advantage to this type of annuity is the fact that the insurance company does not pay any tax on the income it earns by investing your premiums. So you've got that shelter during the period until the annuity starts. And once the annuity starts, you're going to pay tax as ordinary income on that portion of each annuity payment that isn't a return of your original premiums. I said it's ordinary income. The annuity payments are eligible for the $1,000 interest, dividend, and capital gains exemption. A fourth category of investment for deferring recognition of income is an investment in a tax haven mutual fund. These are mutual funds that are set up in Bermuda or in the Bahamas or other jurisdictions where there's no income tax. The idea being that it being an ordinary mutual fund, but that as the fund invests, realizes capital gains, receives income, there's no tax as you go through the piece. There's no dividends or anything else like that paid on the units of the mutual fund, but the value of your unit goes up as the overall value of the fund goes up. So that ultimately, when you cash in your unit, you're going to receive a capital gain, but down the road. Again, that's an attractive investment for an individual who is in a high tax bracket now and who's coming close to retirement and would be willing to cash it in, say, when he's at a much lower tax bracket. A fifth category is the Registered Education Savings Plan. This is a plan that's recognized under the Income Tax Act. It's a publicly offered plan whereby you pay amounts now while your child is in elementary and in secondary school in return for the plan paying for the child's university tuition. I haven't heard much about them recently, so I don't know what's happening with them. But the idea under the Income Tax Act is there's no tax on the income earned in the plan, but rather it's taxed as it's paid out, but it's taxed in the hands of the student who probably is able to who probably is not going to pay any tax anyway because of his deductions. Okay, those are all things that an individual can do on his own. Now getting into other categories of using the other members of the family to spread income. In other words, that classic term for all of this is income splitting. And by that I mean the arranging to have income which would otherwise have been taxed in the hands of the principal income earner, taxed in the hands of other members of the family unit. The advantages to this are obvious in that the personal exemptions and low marginal rates of the other members of the family are used. An individual who has no other income can receive up to $30,000 a year of dividends. I'm not sure what the precise amount is now. It's about $30,000 a year of dividends without paying any tax on those dividends. The other advantage to income splitting is it does put income into the hands of students who have got tuition fees that are deductible, which tuition fees would not have been deductible in the hands of if paid by which are not deductible against the father's income. So, it's easy to imagine the case of, again, the father who was sending his child to private school, as I mentioned before. If he had $5,000 of investment income and had a salary of $60,000 as well, if he could so arrange things that $5,000 was earned by his son or on behalf of his son, that the tax on the $5,000 would go from about $2,000 down to nil. Now, against any income splitting are the attribution rules contained in the Income Tax Act. And these are basically as follows. Firstly, that income from property transferred to a spouse is subject to attribution back to the transferor. Capital gains from property transferred to a spouse after 1971, again, attributed back to the transferor. Thirdly, income but not capital gains from property transferred to a minor is attributed back to the transferor. It's not just necessarily between parent and child. It could be between grandparent and child or uncle and nephew, what have you. The income and capital gains from a trust will be attributed back to the person who put the property into the trust if that person has retained certain powers over the transferred property, i.e. he can recover the property, i.e. for example a revocable trust, he's got a power of appointment over the beneficiaries, or he can control dispositions of the assets that are in the trust. Also, that Revenue Canada is talking more about using Section 56(2) of the Income Tax Act, which is dealing with the case where an individual has directed that income not be paid to him, but be paid to somebody else whom he wishes to benefit. That income then is included in the first taxpayer's income. So the essential elements for all of these attribution rules, and they become more like landmines rather than barriers, in the sense that if you don't step carefully, they'll go off, but it is possible to step carefully through them. The income, all right, first of all, it has to be income from property. There's no attribution of income from a business, and there's no attribution of income from reinvested income that's been subject to attribution. Secondly, it has to be from property. Now, the word property, fortunately or unfortunately, recently received a very broad meaning in the case called Murphy versus the Minister of National Revenue and the Tax Review Board. Their property was held to include an interest in a trust, so that we're not just looking just at the underlying assets in a trust, we're actually looking at the interest in the trust. The main loophole in all of this is the fact that courts have said that the word transfer does not include a loan. Revenue Canada goes along with this, but says the loan must be genuine, and they're looking for written evidence of the loan, an agreement to repay the loan within a reasonable time, that there be some security for the repayment of the loan, and that there have, in fact, been actual payments made. Now, they're saying you don't have to have all of these or even any of these, but these factors are evidence of what they feel to be the genuineness of the loan. So that if an individual wants to split income with his spouse, the simplest way of doing it is to lend the spouse cash, evidenced by a promissory note. Then, as a form of collateral security for the repayment of the note, the investments made with the borrowed money could be endorsed in blank and left in the lender's safety deposit box as a form of collateral, as I say. Perhaps then there could be repayments on the loan in the amount of the after-tax income earned by the borrower on the from the investments. One big advantage, of course, the loan is important from an income tax point of view as opposed to an outright transfer. It's also, as you can imagine, important in the event of a marriage breakdown. One point also, though, that it's not enough just to be careful to make sure it's a loan in the first place. The borrowing spouse cannot then turn around and buy assets from the lending spouse, because the sale of assets is a transfer, even though the transfer took place at fair market value. Revenue Canada has indicated that they will enforce this from 1972 on. Now, income splitting with children becomes a bit more complicated, because then you're dealing with minor children or with immature adult children. So rather than go through all of the pros and cons, I'm just going to describe the steps that I've been following in setting up an arrangement like this, particularly when it's a trust to get income into the hands of children to enable them to pay school fees. Firstly, a trust is settled for the benefit of all of the children rather than each individual child. And the settled amount would be, say, $1,000, which would be invested in a bond. As to why that, I'll get back to that in a moment. The parent with the cash then lends the cash to the trust on a non-interest-bearing demand basis. The trustees then, with the borrowed funds, invest the cash and use that income, which they earn from the investment, to pay directly the school fees for the individual children, using their power in the trust agreement to make payments of income to or on behalf of the children. The income then that is applied for the benefit of the children is then taxed in the children's hands, and is then any income that's still left over can be subject to, well, we'll talk about preferred beneficiary elections in a moment. Then, sometime down the road when the children are growing up and the parents are getting closer to retirement, the parents just demand on the loan, the capital then goes back to the parents, and everything is as it was. Probably at this point will be very little income, very little capital or accumulated income left in the trust. And the trust can then just disappear. So there are a couple of questions, though, that have to be resolved in setting up one of these trusts. The first one is the choice of the settlor. I myself have had a concern that the creation of a trust may itself be the transfer of property in the form of the interest in the trust to the beneficiaries, and that it would be possible to argue that any income received on that property, i.e. the interest in the trust, would be subject then to attribution to the settlor. In the situation, though, that I described, where we had a settlement of $1,000, which was invested in a bond and then a borrowing, Revenue Canada, in a recent letter to me, said, no, the only thing that would be attributed to the settlor would be the interest on the bond. No attribution of the income earned with the borrowed funds. So, well, still, though, I prefer not to have the, I'm still somewhat concerned about all of this, and so I prefer to use a grandparent, preferably a non-resident, because then there's a limited exposure then to income attribution, because as those of you familiar with the rules know, there's no attribution to an estate and there's no attribution to a non-resident. By using a grandparent, we're still able to make preferred beneficiary elections because the entitlement to make those elections depends upon the beneficiaries all being direct descendants of the settlor. So far as the choice of trustee is concerned, I've been concerned that if the lender to the trust is also the trustee, that you could add together the powers that the lender has and the powers that the trustee has, and say if they're all in one person, then the Section 75 sub 2 would apply. Remember, that was the case of this individual who would put money into a trust and retain certain powers over that property. Again, Revenue Canada has said, no, you don't add them together. Their answer on 75 sub 2 does not depend upon who the lender is or who at all. I still, though, prefer that the lender not be the trustee. So then the ideal situation would be to have a grandparent as the settlor. If it's father that has the money, then mother's the trustee. Father then lends the assets to the trust. Now, so far as the taxation of the income that is earned in the trust, as I mentioned earlier, the income from the $1,000 bond, if it's paid to the beneficiaries, is attributed to the settlor. So, in fact, you use that income to pay expenses. The income from the investment of the borrowed funds, there's no attribution to anyone. And then the income that is paid to or on behalf of the children is taxed in their hands. And the income that is subject to the preferred beneficiary elections is also taxed in their hands. Now, just to refresh your memory as to what these elections are, they're basically an agreement between the beneficiaries and the trustees that the beneficiaries, although they didn't receive the income, will pay tax as though they did. And just on that score, it's my view that the entering into a preferred beneficiary election is no way a designation of the income to that particular beneficiary for trust accounting purposes. Then the object also is not to leave any income behind in the trust to be taxed in the trust, because the trust has a minimum 50% tax rate. Now, just to digress for a moment and talk about some recent developments in the taxation of trusts, three things: tax ruling number 80, Sachs versus the Minister of National Revenue, and the revised interpretation bulletin IT 260R. Now, tax ruling 80 was one dealing with a situation where father was transferring capital, was contributing capital to a trust of which he and mother were the trustees. There's no loan involved here. They asked for a ruling that Section 75 sub 2 would not apply, and they got that ruling. It's interesting to note that one of the things that would make 75 sub 2 apply is if there's a possibility that the assets in the trust will revert to the contributor to the trust. These trusts, though, were so drawn that if there was a complete failure of issue, then the capital reverted to mother, not to father, who was the contributor. Well, I understand, I believe, the Morris Cullity, you had an exchange of letters with the department in which they said that 75 sub 2 was not intended to cover the possibilities of reverter on the failure of the trusts. Second ruling that they asked for and got was, I'm sounding like Gourmet magazine. We asked for and got the recipe for this. There's no attribution of, the ruling was that there was no attribution of income once the children were age 18. There was, however, in the ruling no discussion of what happened with respect to the income before that date. And thirdly, they said that Section 104 sub 2 would not apply to these trusts. Now, there's a separate trust set up here for each of the children. Now, that point is really almost an academic point because of now the high tax rate on the trusts. But it is interesting that the department does consider that if you have a separate trust for each child, they will not then try to aggregate the trusts, even though the wording of Section 104 sub 2 is not as clear as it might be. This may have relevance in determining whether, if you've got offshore trusts, and you're determining whether or not you've got any particular trust holding a certain percentage of shares in a foreign affiliate. Now, so far as the case of Sachs versus the Minister of National Revenue, that was a case in the Tax Review Board where the income of a trust was in fact paid to minors, and it was attributed to the father who transferred the property to the trust. There again, there was an actual contribution of property to the trust. Now, the wording of the case is such that a number of people have taken from this the inference that the income that is in the trust will be taxed in the hands of the children, even though it's not paid out. I don't read the case that way. In fact, what I read the case as saying is that there was a transfer to the children of the property that was put into the trust because the children had a vested interest in the trust. And that was the whole issue, as to whether or not there was a vested interest in the trust. So you remember that under the attribution rules, there has to be a transfer of property to a minor. And what this case held was that when you put property into a trust in which the children had a vested interest, even though that interest might be subject to divesting, then there has been a transfer of property to the child, and then, if the child receives income, the attribution rules will apply. I don't think it means, as I said earlier, that the income that stays in the trust is going to be subject to tax. That the income that stays in the trust is going to be attributed to father. It doesn't mean that. Now, Interpretation Bulletin IT 260R, for what it's worth, agrees with my interpretation of the Sachs case, and in that it says that the attribution will depend upon the child having a vested right in the capital of the trust, even though that right might be subject to divesting. It does, however, suggest, by omission, that if you so concocted your trust that nobody had a vested right but had only contingent rights to the capital down the road, there would be no attribution. So, for example, if you were to put in a power of appointment, give a power of appointment to someone, say father contributed to the trust, mother had the power of appointment, that you might then have to be able to say that no child had a vested right, and therefore there would be no attribution. It's perhaps interesting to explore. I, however, have never fully understood the distinction between rights which were vested subject to divesting and contingent rights, and I had hoped that we'd got rid of them. It seems to be Revenue Canada wants to bring them back. Now, the other thing that IT 260R changed was that it publicly announced Revenue Canada's revised position with respect to preferred beneficiary elections. Basically, they say that if there is a preferred beneficiary election and income is allocated to a beneficiary of a trust from property that was contributed to the trust by a parent, there would be allocation of that income to the parent, or attribution, rather, of the income to the parent. This is, I think, contrary to the inference that was in old IT 260, and certainly is contrary to letters written by Ivan Linton when he was the head of technical interpretations for Revenue Canada. What it depends upon, for those of you who like to read words and play with them, the section that says that income subject to preferred beneficiary is going to be taxed, or brings it into income, it says that income subject to preferred beneficiary election is to be included in computing income of a beneficiary. Now, for the attribution rules to apply, it has to have been the income of the beneficiary. Does it mean the same thing, then, that does including in computing income mean that it is income? I don't know the answer to that one. However, the point that I'm making here is that if the trust is set up with a loan rather than a contribution, you never really get into all of these problems anyway. So in conclusion, with respect to the trust for children, I'm just saying that the trust should be settled with the nominal amount cash lent into the trust. Again, don't buy assets from the parents. But if there is a desire to transfer assets for the benefit of children, then it's necessary to use a holding company. And then the holding company shares are purchased with money, with funds borrowed by the trust. Okay, we've now come to talking about corporations. First of all, there's a maximum rate of about 49% on investment income earned in a corporation. That is to say, investment income other than dividends from taxable Canadian corporations. And this compares favorably with a top marginal rate of 62% for an individual. The tax on dividends from taxable Canadian corporations is all refundable tax of about 1/3 of the amount of the dividend. So there's no attribution of income. Also, if father transfers assets to a corporation, the shares of which are owned by his wife or by his children, there is no attribution of income from those transferred assets. So it's a method of breaking the attribution chain. A third advantage to using a corporation is that there is now only one portfolio being invested. We were talking about transferring assets to lending money to the wife so that she could buy a portfolio, lending money to a trust for the children so the trustees could buy a portfolio. So you end up then with 3 or more portfolios. By using a corporation, you've brought it all back together, much greater ease of management. Next, of course, father can now retain control over the investments in the trust through voting control of the corporation. Final advantage of a corporation, which has nothing to do with income tax planning, but it has to do with estate tax planning, is that it fixes the situs of the assets that are in the family's estates here in the jurisdiction in which the corporation is incorporated and has its transfer office. So, for example, if an individual holds a portfolio of securities, some of which are U.S. investments or investments in corporations with transfer offices only in Quebec, by putting those investments into a corporation, into an Ontario corporation, then the only asset held is Ontario securities, is on shares of an Ontario company, and there's no U.S. estate tax on those investments at all. So the structure that I've been using recently for holding assets in a portfolio is to start with having father incorporate the corporation and subscribe for common shares. Father then rolls the portfolio into the corporation for debt equal to his adjusted cost base and shares for the difference. Now again, we're only talking about a portfolio. We're not talking about a connected or controlling interest in another corporation. The corporation then borrows cash from a bank and uses that cash to repay part of the debt which it has to father. Father then takes the cash he now has and lends it to a trust that has been established for his children, and that trust subscribes for non-voting retractable preference shares of the corporation, putting the money back down into the corporation. The terms of the preference shares provide that they have a priority on wind-up, but as to payment of dividends, that's completely in the director's discretion. Next, the corporation uses the money from the issuance of the preference shares to repay the bank loan. So we just circle the money right around. We then repeat the whole process to pay cash to father. He lends it to mother. She then subscribes for another class of preference shares. Now, we then have got an ability on the director's part to pay dividends on the preference shares held by the children's trusts, dividends on the preference shares held by mother, and finally dividends on the common shares held by dad. The dividends paid to the trust and the children, however, I think have got to be reasonable relative to the size of their investment. And that's why I've gone through this whole exercise of having the money that's put into the shares for the wife and children be a significant amount of money, because I'm concerned about unreasonable dividends relative to the amount of invested capital. Now, one other point is, so what kind of shares should father take back on the transfer of assets into the corporation? You could take back common shares, but that doesn't necessarily give him the ultimate flexibility. And again, with all of this stuff, you have to gauge your client by his ability to understand what you're talking about. But if you want to get really subtle about it all, you've got the choice of father taking back a third class of preference share, with the choice of either having a high paid-up capital on those shares or having a low paid-up capital but a high redemption amount. If he takes back high paid-up capital on the redemption of those shares, it's going to be a capital gain. If he takes back a low paid-up capital on the redemption of those shares, it's going to be a deemed dividend. If, however, during the time that the shares have been in place, the corporation has earned capital gains, thereby creating a capital dividend account, the deemed dividend on the redemption of those preference shares could be out of that account, and so he could get it back tax-free. Now, what's the result of all of this corporate structure? First of all, you'll note that I haven't frozen the value of father's interest. And with a portfolio, I don't think freezing is important anymore. Okay, Marvin, 5 minutes. Sit down, will you? You make me nervous. He wanted me to go to 12 o'clock. First of all, as I say, I don't think freezing is important anymore with respect to portfolio investments. We're not dealing with succession duty, so we're not looking at a wealth tax. The only tax we're looking at is a deemed realization on death of accrued and untaxed gains. But if you've got a portfolio which is being rolled over fairly frequently, the gains are being taxed as you go along. So therefore, the whole purpose of a freeze isn't as important. Secondly, but perhaps more important these days, is the psychological fact that father isn't frozen. We're seeing all the time now clients for whom we set up beautiful freezes coming into us with very long faces because they're very worried about their own financial security. And if we're going to see continuing inflation at double-digit rates for the next decade, I'm very concerned about freezing. So with the structure, though, we've now got the ability to pay out into the family's hands only the amount of income that is required in any year or required to use up low tax rates. The balance of the income stays in the corporation and is taxed at its rates. We've also got the flexibility of making payments to the various members of the family in the appropriate proportions. The flexibility comes among the trust, the wife and the husband, by paying the dividends in varying amounts in their classes of shares, and among the children by exercising the discretions in the trust. The payments from the corporation are going to be taxable dividends entitled to the dividend tax credit, so again, the children can receive substantial amounts of dividends without paying any tax on it. And the fact that I've used non-preferential dividends, in other words, discretionary dividends, means that you don't get into the business of having to waive dividends each year, and so you're not dead on with the department's developing position in this regard. Now, the disadvantages to this are a number. Number one, a corporation can't buy an income averaging annuity. It's going to be the cost of compliance, legal and accounting fees to just keep this corporation going. As I said, the dividends from this corporation are not going to be eligible for the $1,000 deduction, so you may have to add another bell or whistle onto the whole scheme and have the Children's Trust hold bonds to generate arm's length income to use up the $1,000 deduction. And there is going to be this old bugaboo of the theoretical double taxation of the capital gains in father's common shares and the capital gains in the underlying assets in the corporation, which requires some steps to be taken on father's death to eliminate the doubling or acceleration of the tax on the accrued gains. Now, just finally, a few comments on the position of Revenue Canada towards all of this. They seem to be tolerating the splitting of income by among members of the family by way of so-called genuine loans. This is a long-standing practice, and they don't seem to be wanting to attack it. A lot of us have been looking at every budget for some change to this provision. I think would now require a budget change. They seem to tolerate it. I've also heard off-the-record comments from various members of the Department of Finance. They're not particularly concerned about income splitting between husband and wife. They're more concerned about splitting between generations. You've also got the attack in cases like the Titley case, which was a case where wives received dividends on a company that was way in excess. The annual dividends were many times that of their original paid-up capital. However, I said the department is willing to say that if it's the common shares that are receiving these big dividends, they're not nearly as concerned as if you had a non-participating $1 preference share that was receiving a $10,000 dividend a year. Because common shares, it stands to reason that they will share in the capital growth and ergo the increased earnings of the company. The waiver of dividends on preference shares is now, the department is starting to make noises about that. They seem to want to have either the dividends paid on those preference shares or they want an equivalent amount staying in the company and being taxed there rather than being paid out to the children. They seem to be concerned about setting up a structure whereby the first dollar of income earned in the corporation is going out to the children, even though father has put his value in. So what's the difference between father transferring his assets in return for retractable preferred shares on one hand and is having a demand note, which they're not upset about? Well, really, they're not the same, because usually on a freeze, particularly of an operating company, where the father's taken back preference shares, he's got a huge accrued gain in those shares, so they're not really a demand security. It's going to hurt him a lot to make that demand. So, the last thing I have to say then is really the department is not going to give you very helpful rulings in all of this, and I'm afraid all you can say to your clients in setting up these plans is you're doing your best, but there are no guarantees. Thank you very much.